All right, welcome everybody. Thank you so much for joining us here today on the webinar. Today we have the chair and the vice chair of the Appraisal Standards Board, and they will be summarizing the board's proposed changes to USPAP. Michelle and Nick, would you both like to take a quick moment to introduce yourselves?
Yes, good morning, everyone. Thank you for your time and attending. I am Michelle Chikolski-Bradley, Chair of the ASB. I'm a certified general appraiser and AQB certified USPAP instructor from our rural area outside of Pittsburgh, Pennsylvania, and I practice in the residential real property world. Welcome.
Yeah, hi everyone. I am Nicholas Piltz. I'm a certified general appraiser in the Orlando metro area. I'm also an AQB certified USPAP instructor. I work in the world of commercial, residential appraisal, appraisal review, and litigation. And thank you.
Great, thank you both. And I am Lisa Damaris, the Vice President of Appraisal Issues here at the Appraisal Foundation, and I serve as the technical expert to the Appraisal Standards Board and to the Appraiser Qualifications Board. So I was an appraiser in the field for 30 years prior to coming here to work full time. Now, before we begin, here are, as always, we always do the very quick housekeeping notes that I run through. We are recording the webinar. You should see the recording post to our website and our YouTube channel in approximately 24 hours. We will take questions at the end of the webinar. To ask a question, you can move your mouse to the bottom of your screen. A menu will pop up, and one of those options says Q&A feature. You can type your question right in there. We prefer you don't type it in the chat box because we have different information going and different people watching different boxes. But if you do, we will try and catch it and get it transferred over to the Q&A box as possible. At the conclusion of the webinar, you will have a very, very quick and brief survey pops up. It just asks you what we could change. And those matter greatly to us. We often make changes to these webinars based on those comments. So if you can fill those out, that would be great. For the agenda today, we will discuss the proposed edits in USPAP to the ethics rule that is presented in the fifth exposure draft, and we will briefly review the proposed changes to other parts of USPAP. Michelle and Nick will explain the rationale for these proposed changes that have been issued by the board. And also, based on the amount of information we have to cover today and the number of questions that we anticipate, it's possible we may go over time just a bit. So just be prepared that that may happen. To submit comments to us on the fifth exposure draft, you can either email us your comments, or the email address is in the fifth exposure draft, or if you have the fifth exposure draft up on your computer at any given time, you can just click on comments, put you right into a way that you can submit those comments to us directly.
Thanks
Michelle.
a lot, Lisa. Thank you. And yeah, folks, if you follow along in the fifth exposure draft, the email box is right there. You can send comments live to us. So folks, if you haven't provided your comments yet, we sure hope you do soon. The ASB issued the draft on March 30th. We're asking for all comments to be submitted by April 29th. That is in advance of the ASB public meeting, which is going to take place live via Zoom on May 5th. I'm going to repeat that, live via Zoom on May 5th. We hope that you will register on the link that's going to be posted in the chat box. The board regularly solicits and receives comments and suggestions for improving USPAP. Proposed changes are intended to improve USPAP understanding and enforceability, and of course, to achieve the goal of promoting and maintaining public trust in appraisal practice. Now, Nick and I are going to go over the proposed changes shown in the fifth exposure draft in detail, and we are going to take questions at the end. We sure hope that most of your questions are answered in the presentation, so let's jump right in. For those of you who might not have been following along from each separate draft, 1 through 5 now, I'd like to give you some context on how we arrived at where we're at right now. So back in June of 2021, the ASB issued a discussion draft, and one of the questions asked in that discussion draft concerned the use of the terms unsupported conclusions and bias, and specifically whether those terms as used adequately communicated that USPAP prohibited discrimination and the legal context related to that prohibition. The predominant feedback that the ASB received on the discussion draft and on the comments to the subsequent first and second exposure drafts was that the language in the ethics rule was insufficient to make it clear that USPAP prohibits discrimination. As a result of this feedback, and after consultation with anti-discrimination experts, in July of 2022, the ASB released a third exposure draft. And that draft proposed to address these concerns by adding a non-discrimination section within the ethics rule and deleting all language relating to supported and unsupported conclusions within the conduct section of the ethics rule. The ASB received extensive feedback on the third exposure draft, predominantly in favor of including a new non-discrimination section. The comments received also reflected a need for greater clarity on the legal concepts introduced in the proposed section and better conformity with USPAP terminology and style. So as a result of that feedback, in December of 2022, the ASB released a fourth exposure draft that revised and refined the language in the proposed non-discrimination section. The rationale released in connection with that fourth draft previewed concepts to be covered in guidance that would be promulgated in the event that the fourth exposure draft was adopted. Feedback was received from the fourth exposure draft continuing to predominantly favor the inclusion of a non-discrimination section in the ethics rule. The feedback also reflected a concern about the use of two new terms introduced in that draft, designed to draw a distinction between illegal and unethical discrimination. Commenters noted that the fourth exposure draft's introduction of these terms implied that there was such a thing as ethical discrimination, and also that this distinction made the relationship between anti-discrimination laws and USPAP less clear. Feedback also reflected a desire from stakeholders to review guidance on the non-discrimination section prior to its adoption. The proposed non-discrimination section continues to propose omitting all material relating to supported and unsupported conclusions. This is how it looks here on your screen. Note that the bullet point proposed to be stricken is the one related to the supported, unsupported conclusions.
Thanks, Michelle. How about we jump right into the non-discrimination section?
Okay.
What would you like our listeners to know about why the ASB is proposing this new section of the ethics rule?
Well, first, I want everyone to see where we're proposing the addition of the new section. It's right there on your screen in the last sentence. The ethics rule will be divided into 4 sections, which includes the non-discrimination section, as well as the others that already exist in the rule. So now let's jump into that why. This proposed new section is designed to maintain and further ASB's deep commitment to upholding the public trust and the congressional authority granted to the ASB under Title 11. As a result of feedback to the fourth exposure draft, which requested guidance material to be exposed along with the proposed rule, the ASB has prepared the proposed changes to the ethics rule as well as the proposed new advisory opinions 39 and 40. Exposing the proposed guidance along with the proposed edits to the rule is done at the request of stakeholders and for transparency. The changes to the proposed section and the drafting of related guidance were undertaken in consultation with fair housing, fair lending, and anti-discrimination experts, as well as stakeholders within the appraisal profession. And despite some changes to the proposed non-discrimination section structure and language, it still maintains a focus on core concepts from key anti-discrimination laws. The newly proposed section explicitly continues to require that appraisers be knowledgeable about and follow anti-discrimination laws that apply to the appraiser or apply to the assignment. Consistent with prior drafts, this 5th exposure draft continues to propose omitting all material relating to supported and unsupported conclusions. At the same time, the ASB recognizes that additional guidance would be beneficial to illustrate the application of anti-discrimination laws and related concepts to appraisal practice. And by exposing the proposed advisory opinions along with the proposed non-discrimination section, the ASB intends to provide stakeholders all information needed to evaluate this section. Not all anti-discrimination laws are applicable to all appraisal disciplines. However, as a matter of ethics and public trust, the ASB views it as critical to set out non-discrimination requirements for the appraisal profession as a whole, regardless of appraisal discipline. The 5th exposure draft deletes the concepts of illegal and unethical discrimination that raised concerns in the 4th exposure draft. The proposed non-discrimination section further clarifies that non-discrimination obligations exist for all appraisers, regardless of whether specific anti-discrimination laws apply to the appraiser or to the appraiser's assignment. The proposed section begins by prohibiting an appraiser from acting in a manner that violates or contributes to a violation of federal, state, or local anti-discrimination laws or regulations. It highlights the Fair Housing Act, the Equal Credit Opportunity Act, and the Civil Rights Act of 1866, the 3 key federal anti-discrimination laws that are relevant to appraisal practice. The proposed section also requires an appraiser to have knowledge of anti-discrimination laws and regulations and when those laws and regulations apply to the appraiser or to the assignment. The proposed section then states specific prohibitions that apply when the appraiser is completing a residential real property assignment or an assignment where the intended use is in connection with a credit transaction. These prohibitions, grounded in the Fair Housing Act, ECOA, and the Civil Rights Act of 1866, plainly state that an appraiser is prohibited from basing their opinion of value on any of the characteristics protected under relevant law. Under the prohibition related to residential real property, a comment states, again in plain language, what the Fair Housing Act prohibits and that the Fair Housing Act can be violated through disparate treatment and disparate impact, concepts that are further discussed in guidance. The comment also highlights sections 1981 and sections 1982 of the Civil Rights Act of 1866, which broadly apply to appraisals, including real and personal property appraisals. Under the prohibition related to assignments where the intended use is in connection with a credit transaction, a comment states in plain language what ECOA prohibits. Now, the non-discrimination section that's proposed continues with 4 additional prohibitions, and they apply across appraisal disciplines regardless of whether or which anti-discrimination laws or regulations also apply. These prohibitions apply with respect to an enumerated list of personal characteristics that are drawn from federal anti-discrimination protections, namely the actual or perceived race, ethnicity, color, religion, national origin, sex, sexual orientation, gender, gender identity, gender expression, marital status, familial status, age, receipt of public assistance income, or disability of any persons. An appraiser must not develop and or report an opinion of value based in whole or in part on any of those listed characteristics. An appraiser must not base an opinion of value upon the premise that homogeneity of the inhabitants of a geographic area is relevant for an appraisal. An appraiser must not perform an assignment with bias with respect to any of the listed characteristics, and an appraiser must not use or rely upon any characteristic as a pretext to conceal the use of or reliance upon a listed characteristic. Finally, the proposed non-discrimination section recognizes that limited circumstances exist where use of a protected characteristic in an assignment would not constitute discrimination and would not violate the ethics rule. For use of or reliance upon a protected characteristic in an assignment to be permissible, the use or reliance must not be prohibited by anti-discrimination laws and regulations, and must further be essential to the assignment and necessary for credible assignment results. And these requirements are intentionally stringent. Details about the use of this limited exception are provided in guidance. And the operation of this exception is similar to the one from the 4th exposure draft. However, the framing of this limited exception for the 5th exposure draft has been modified to increase the clarity of the relationship between the exception and the requirements of anti-discrimination laws and regulations. The 5th exposure draft also removes a prior 3rd requirement. I'm referring back to the 4th exposure draft. This 5th exposure draft also removes a prior 3rd requirement that the appraiser's use of or reliance upon a protected characteristic cannot be due to bias, prejudice, or stereotype. The feedback received on that language indicated it was confusing and would be difficult to enforce. The remaining elements of the exception, that the use or reliance be permitted by anti-discrimination laws and regulations and be essential to the assignment and necessary for credible assignment results, that appropriately limits the circumstances under which use of or reliance upon a protected characteristic can be allowed. In practice, consideration of a protected characteristic based on bias, prejudice, or stereotype is never necessary for credible assignment results. So guidance, advisory opinion 39 notes that both the ethics rule and the competency rule require an appraiser to understand and comply with all applicable anti-discrimination laws, whether it's at the federal, state, or local level. It gives further guidance for when an appraiser can violate or contribute to a violation of applicable anti-discrimination law. It provides additional background on the Fair Housing Act, ECOA, and the Civil Rights Act of 1866, and how these laws and their implementing regulations are relevant to appraisal practice. It also explains in greater detail the concepts of disparate treatment and disparate impact. Additionally, the proposed advisory opinion 39 provides additional guidance and illustrations regarding the narrow circumstances in which use of or reliance upon protected characteristics is permitted under the proposed non-discrimination section. The proposed advisory opinion 40 provides greater detail on the requirements of applicable anti-discrimination laws and USPAP in the context of residential real property appraisal assignments. Building on the discussion of the Fair Housing Act and other relevant laws and regulations in the proposed AO 39, the proposed AO 40 provides guidance related to the prohibitions on using particular protected characteristics in developing an opinion of value for residential real property assignments, and in the research, analysis, and reporting of location-related data, including demographics, for these types of assignments. It also discusses the relationship between the USPAP prohibition on pretext and code words that can indicate discrimination. The proposed non-discrimination section of the ethics rule and the accompanying proposed advisory opinions 39 and 40 are designed to maintain and further the ASB's steadfast commitment to the highest professional standards in appraisal practice. Of course, if any changes to USPAP are adopted, training will be aligned to reflect the updated sections of USPAP. The ASB is proposing to retire advisory opinion 16. There are the two proposed new advisory opinions that I just went over, that's 39 and 40, that are included in the 5th exposure draft, which include a very comprehensive illustration of concepts related to fair housing laws and non-discrimination. So Lisa, that's a detailed overview of that section.
Sure is. Great job, Michelle. Now that we are done with the proposed changes related to the ethics rule, let's look at other proposed changes to USPAP. Nick, would you like to lead us through this section?
Sure. Thanks, Lisa. Here, the transfer and sales section is the same as proposed in the 4th exposure draft, so we'll just review this briefly. For real property, personal property, and business appraisers, under certain circumstances where the appraiser is required to analyze prior sales of a subject property, it has been brought to the ASB's attention that while a sale of a property is essentially a transfer of a property, there is a minor technical difference between the two. A sale always includes a transfer, but a transfer may not always include a sale. An example of this for business appraisers is that some companies sell, and those sales are often structured in ways that are not considered true sales. This can be a reorganization, a merger, a legal process, or some other conveyance of an interest from one person entity to another that may even be a partial transfer of the business. While USPAP guidance has always maintained that a sale and a transfer are essentially the same, enough questions have been raised about this issue that the ASB is proposing this change. The addition of the words "and other transfers," if adopted, would then appear in the development and reporting standards as appropriate. From here, we're going to go into definitions to retire. These have been discussed previously too. With the definition of assignment elements, we'll start there. The ASB has proposed to remove the definition of assignment elements. The current definition includes a list of assignment elements as stated in problem identification section of the scope of work rule, which are applicable in every appraisal assignment. However, there is a in a few circumstances, there is a slight difference. The definition may not be the exact ones that are applicable in some appraisal review assignments. For the definition of misleading, we're also proposing deletion of that definition. This definition has received a lot of criticism, although if the change is adopted, the term would revert to the common dictionary definition and will no longer have a specific USPAP definition. For relevant characteristics, the definition of relevant characteristics is proposed for deletion to avoid drawing a distinction between the phrase relevant characteristics and phrases like property characteristics relevant to the assignment and characteristics of the property that are relevant to the type and definition of value. These two phrases have the same meaning as relevant characteristics. Defining one term but not the others implies there is a difference, yet there is none. So let's go on to definitions to modify. The current definition of appraiser in USPAP is one who is expected to perform valuation services competently and in a manner that is independent, impartial, and objective. The ASB is proposing to reinstate the following original comment that appeared in the 2018-2019 edition, as seen here on the screen. Prior to the removal of the comment had existed in the definition since the year 2000, It was removed from the current edition after exposure to the public multiple times with no objection. However, subsequently, it was recognized by stakeholders that the comment made it clearer where the expectation to comply with USPAP comes from, and the comment was needed to fully understand the definition. While Advisory Opinion 21 explains the relationship between the expectation and who should comply with USPAP, and the preamble explains the concept of what it means to comply with USPAP, stakeholders stated that this is not enough. Therefore, the ASB is proposing to reinstate the comment exactly as it appeared in the prior editions of USPAP because the comment made it abundantly clear without having to look at different sections of USPAP, where the expectation comes from for an individual who's acting as an appraiser should comply with USPAP. If adopted, the definition would appear exactly as it previously appeared in the 2018 and 2019 USPAP. So now we're getting into definition to modify personal inspection. Prior exposure drafts had proposed the definition, the deletion of the definition of personal inspection and introduction of a requirement to disclose the type and extent of inspection as part of scope of work reporting. Additionally, prior feedback from stakeholders indicated that there was a need to address the appraiser's inspection, particularly in light of technology. Thus, previously, the ASB proposed the addition of new disclosure requirements, which would add a sentence clarifying the scope of work reporting requirement to standard 2, 4, and 8. Specifically, whenever one or more inspections of the property that is the subject of a report occurs, or for an appraisal review, whenever an inspection of the property that is the subject of the work under review occurs, the previously proposed edit would have required the report to contain information on both the type and extent of that inspection. Type and extent are elaborations of the requirements of the scope of work rule. And while including a requirement to report specifically the type and extent of the appraiser's inspection is one possible solution, a more direct solution is modifying the definition of personal inspection. Edits to this definition in the 5th exposure draft are proposed to clarify the appraiser's inspection that is part of the scope of work for the assignment, contrasted to an inspection that is completed by a third party outside of the appraiser's scope of work. After considerable analysis, the ASB is proposing to modify the definition of personal inspection and is also exposing an updated advisory opinion to inspection of the subject property, which illustrates the applicability of the proposed definition. The proposed guidance in the updated AO2 illustrates the applicability of the revised definition, includes guidance regarding the appraiser's disclosure obligations relating to a personal inspection. The guidance answers the following questions. What is the purpose of inspecting a subject property? What is a personal inspection? Is an appraiser's inspection different than a third-party inspection? When is an inspection part of the appraiser's scope of work? Does USPAP mandate a minimum level of property inspection? What are appraisers' disclosure obligations relating to an inspection? And when does a personal inspection conducted as significant appraisal assistance require disclosure? I encourage each of the attendees to review the proposed guidance and provide the ASB with the necessary feedback. We have one other definition to discuss here to modify, that's work file. As previously proposed, the ASB is considering amending the definition of work file as shown here on the screen. The preamble states that an appraiser must maintain the data, information, and analysis necessary to support his or her opinions for the appraisal or appraisal review assignments. Therefore, a main purpose then of a work file is to contain the documentation necessary to support the appraiser's opinions and conclusions. However, the work file also serves other purposes. For example, an appraiser can also choose to retain additional materials that go beyond showing compliance with USPAP, such as materials used to answer questions, document correspondence with the client, or to provide background information on a business contract. To reflect what the ASB intends for the work file to contain, and not restricted to just materials specifically intended to show compliance with USPAP, the ASB proposes the modifications shown here.
Great job as well, Nick. Thank you. There are some minor edits left to explain, and Michelle, would you lead us through those sections?
Yes, I'd be happy to. So, of course, sometimes changes require a closer look at some of the individual words used in USPAP. There are 4 proposed edits that either update a term, create consistency between the standards, solidify a concept that already exists in USPAP, or refine a meaning. These are not significant changes and should have minimal impact on an appraiser's day-to-day practice. The ASB is proposing to replace the words "a summary" to instead be "the description" in one sentence in each of the certification requirements for standards 2, 4, 6, 8, and 10. And to explain this change, I'm going to use standard 2 as an example. In the reporting standards, and specifically the certification requirements, there is a section that deals with significant appraisal assistance and where disclosures related to the assistance may appear in your report. You see on your screen the comment. I'm not going to read it to you, but you can all see it on the screen. The proposed elimination of summary and the addition of the description. The requirements to report the extent of any significant appraisal assistance, of course, come from the requirements for an appraisal report or a restricted appraisal report. Individually, each requirement is for an appraisal report to summarize the extent of any significant appraisal assistance, or for a restricted appraisal report to state the extent of any significant real property appraisal assistance. So of course, depending on which reporting option you use, the appraiser is required to, at a minimum, either state or summarize the extent of the assistance. And to be certain that both options are encapsulated in the requirement, the ASB is proposing to replace the word summary with the word description. Standard 6. This addresses how an appraiser should report the results of a mass appraisal. The ASB has always held that Standard 6 does not include an option for an oral report. However, this exclusion is not directly stated, as recently noted by several stakeholders. In response, the ASB proposes the current edit to the opening line of Standard 6 so that it is abundantly clear. You can see on your screen the proposed addition. The ASB proposes adding words to a requirement in Standards Rule 8-2B so that it is consistent with the exact wording that already exists in 8-2A. This proposed change has already been exposed several times for adoption. There have been no notable objections. It is not a concept change. It is not an added requirement. Rather, the addition of these words would make the language in 8-2 internally consistent. You'll see on your screen the proposed wording, and note that what we're showing you on the screen, this also shows the proposed wording we discussed earlier in the transfers and sales discussion.
Great. Thank you both. We'll take a quick breath there. There was a lot of great information.
That was, that was a lot of stuff, and we tried to go through that as quickly as we could so we can get to some questions.
Well, you'll be happy to know I've got about a question every 30 seconds coming in here. So I'm going to do my best to kind of look at them all real quickly and just read them to you, the ones that are kind of overlapping, and I'll direct them to each of you. You guys can answer. We have a good amount of time here, so thank you for going quickly through those. How about, let's see, I'll start with Nick. Why is appraiser liability of third-party inspections not addressed in the proposed definition of personal inspection in the 5th exposure draft?
All right. Well, thanks, Lisa, and thanks for the question. So the Appraisal Standard Board writes, amends, interprets USPAP to serve as the professional standards for appraisal practice. The goal of the ASB is to promote and preserve public trust in the profession by clearly defining the appraiser's role in performing a personal inspection. So users and the broader public will know what the appraiser did, and so users and the broader public could know what specifically the appraiser did when performing the inspection and what the appraiser did not do when performing an inspection, or if they did not perform the inspection. So there's other types of inspections too, maybe ones that involve technology and do not involve an in-person observation of the property. So it's important to note that this term is defined specifically in the context of USPAP.
Thank you, Nick. Michelle, same topic. Can a home inspector provide a personal inspection?
That's a great question. I'm really glad for people to be providing these. And boy, there are a lot of questions about personal inspection and inspection related that I saw in the chat box there. So the question is, can a home inspector provide a personal inspection? Well, if the ASB adopts the proposed definition of personal inspection that's in the 5th exposure draft, only an appraiser would be able to conduct a personal inspection as it's defined in USPAP. An individual who's not an appraiser may still view the subject, either interior, exterior, both. But that individual who's not an appraiser simply would not be conducting a personal inspection as it's defined in USPAP.
Great, thanks.
Mm-hmm.
Well, since we're on the inspection, why don't I just go through a few more of the inspection questions and then I'll get on to a different topic. Nick, this is for you. If I rely on an inspection performed by an Uber driver, how am I not going to violate USPAP?
Okay, thanks for the question. I think that one kind of builds off the first question a little bit. So let me try to give a little bit different response. Relevant information that an appraiser comes in contact with must be evaluated the same way. And it is only the appraiser that can determine the scope of work. So if the information, and it doesn't have to be information about a subject property from the Uber driver, the subject could have recently been listed for sale on local MLS, and that information might be used as part of a desktop appraisal. If that information that the appraiser comes in contact with isn't sufficient to produce credible assignment results, it's the appraiser that has to make that decision to expand the scope of work. So if the client does not want to expand the scope of work for whatever reason, there won't be a way to produce a credible assignment, and the appraiser has to then withdraw from the assignment. So just because the appraiser receives a third-party inspection report, the appraiser still must conclude if they need to gather additional information.
So basically, you're saying like the third-party inspection report is very similar to just MLS data. It's just data.
It's information the appraiser comes in contact with, and they have to decide what to do with it.
Great, thank you, Nick. Michelle, if a property inspector doesn't have to follow USPAP, how can I rely on their data?
Lots of inspection questions. Okay, so if a property inspector doesn't have to follow USPAP, how can I rely? Well, only appraisers have to comply with USPAP. Non-appraisers have no requirement to comply with USPAP. This question really comes up so very often. Let's just look at this a second longer. So appraisers regularly use data. You just said similar to MLS data. Appraisers regularly use data obtained from third-party sources. Lisa just mentioned MLS data, your county assessment records, real estate agent data, surveyors, home inspectors, engineers. Appraisers rely on third-party data every day, and none of those people have to comply with USPAP. This situation is just very similar. Appraisers must ensure that the data used in their appraisal report is sufficient to produce credible assignment results, regardless of the source of information.
Okay, thank you, Michelle. Nick, how does my trainee fit into the picture of providing assistance if they are doing a personal inspection, or if they're meant to be doing one?
Okay. So when there is significant appraisal assistance, a few situations can play out. And these have been exposed within the guidance material for AO2, I believe. Let me see here. I think it's on page 59 towards the bottom there. So I would encourage you to review that information specifically. Generally, a trainee's inspection may or may not be a personal inspection as defined, and it may or may not be significant real property appraisal assistance. So this is further addressed in the in the material that has been exposed in the 5th exposure draft.
Okay. Michelle, is there any list on who can perform and who cannot perform an inspection?
So the question is about an inspection, not a personal inspection. Is that correct? So if the question's about an inspection in general, not a personal inspection as it's defined in USPAP, the proposed change to the definition of personal inspection, if it's adopted in USPAP, only an appraiser could conduct what USPAP defines as a personal inspection. That doesn't preclude a client or intended user from asking any number of individuals to inspect a property for the purpose of gathering information that may be relevant to a property's value. Need to reiterate, of course, that USPAP does not require any inspection of the subject property.
Thank you. Let me just do, how about just 4 more questions on inspection? We have a lot of them, so I'll just do 4 and limit that, and then we'll move on.
I think I saw one in the chat box too.
Let's see. So it's Nick. Nick, your turn. Can the ASB mandate that banks accept inspections performed by trainees?
No. So as a reminder, there's no requirement even within USPAP for an inspection to occur. The inspection is a scope of work determination made by the appraiser to assist the client about their question about value. The client may have supplemental standards that go above and beyond the requirements of USPAP, or simply requirements that an appraiser must comply with. So if one of those requirements includes not using a trainee to perform an inspection, the ASB or TAF, for that matter, just has no jurisdiction to tell clients otherwise.
Okay. And 2 more, one for each of you. Michelle, did the ASB and Fannie Mae collaborate on this definition of personal inspection and on writing advisory opinion too?
No. The ASB did not collaborate with Fannie Mae when drafting this exposure draft, but the ASB hears from many stakeholders. There was no collaboration with any of the government entities, but we do, as a board, regularly get feedback, request feedback, welcome feedback from as many commenters as possible. And Lisa, if I could just throw out, I just saw a question in the chat box that asked about the personal inspection definition and whether it applies to trainees or not. And maybe I could just throw it back to Nick, but I just want to throw out that USPAP doesn't mention credentialing. The definition of appraiser is in USPAP. And if you are performing the functions as defined in USPAP, and you are an appraiser as identified in USPAP, it doesn't matter whether you're a trainee or credentialed. USPAP doesn't get into credentialing.
Nice. Thank you for knocking that one out there. However, because you took an extra question, I'm going to take that other one away from you. I'm just going to give one more, Nick, and we're going to do a new topic here. Okay, Nick, isn't an inspection always significant appraisal assistance? I suppose they mean that in the context of somebody helping the appraiser who's signing the certification.
So the answer on that one's going to be no as well. So, and just a reminder in this little stump Nick here, I think it's advisory opinion 31 that addresses assignments involving more than one appraiser. And I believe significant appraisal assistance is discussed in that advisory opinion. So I would encourage anybody who is trying to decide whether or not something is significant appraisal assistance or not to review advisory opinion 31. Line 76 through 91. Okay,
great. All right, let's move on to the next topic. Let's move on to the questions about the ethics rule. This is for Michelle. So why is the ASB making me be competent in all anti-discrimination laws?
So the newly proposed section explicitly requires appraisers to be knowledgeable about and follow anti-discrimination laws that apply to the appraiser or to the assignment. So let me give you an example. It's not all laws It's laws that apply to the appraiser or to the assignment, which by the way is already in USPAP in the competency role. But let me give you an example. So if you're an appraiser in, let's say out west, let's say Utah, and you're not in Florida, and there are specific laws in Florida. If you're an appraiser in Utah, you don't have to be competent about the laws in Florida, of course, provided you're not practicing at all in Florida and the law doesn't pertain to your assignment. But compliance is required when laws apply to the appraiser or to the assignment. That's a distinction, and that's very important. Conceptually, again, folks, this is nothing new. The competency rule already states that, this is going to be Stump the Michelle time now. I hope I get this quote right. Competency rule already states recognition of and compliance with laws and regulations that apply to the appraiser or to the assignment. That's already been in there. I hope I got that quote exactly correct. I'm going to be excited if I did. So that's already in there. So this isn't really anything new. We're spelling this out specifically.
Okay.
And it's when it applies to the appraiser or to the assignment.
Great. And then I have a two-part question. While they were not asked by the same person, they fit together. So
Okay.
the first part, Michelle, I'm going to give it to you again because you discussed this a little bit.
Okay.
The first part is there are numerous references to residential appraisals and residential property in the exposure draft. USPAP applies to commercial properties too. So why the focus on residential?
So residential is specific in the beginning of the non-discrimination section of the ethics rule, and then the ethics rule gets broader. It doesn't apply specifically just to residential properties. I don't know how else to answer that. It's not limiting. The Fair Housing Act is not limited strictly to residential properties.
Okay, yeah, so that's exactly where I'm going with the second question. So does the FHA Act apply to an appraisal when someone's doing a pipeline easement through 100 acres of residential zone property for eminent domain? I know we've been seeing this question circulate around. It showed up again here today. Or does it only apply to an appraisal that I do for a bank?
Well, first I have to say I saw this question on a Facebook appraiser forum first, and I wanted to make sure that we answered it in case it wasn't asked here. So I'm really glad that it was posted in the chat box, because I want every appraiser to know that the Standards Board wants to answer all the questions that you have. So I'm really glad that the person put this in here. Again, the Fair Housing Act is not limited only to appraisals done for banks. Now, this particular very specific question does I think it was a pipeline easement through a 100-acre residentially zoned property for eminent domain. Boy, we need to know a little bit more about the facts of this particular situation. The Fair Housing Act can be implicated by exercises of eminent domain. And it could apply to an easement depending on the effect of eminent domain and easement on the availability of residential real estate. But we don't know all about the facts of this particular, who's the client, who's the intended user. So the key point that I wanted to make sure we answered on this particular question was an appraiser must have the competency to know when an act applies to the appraiser or to the assignment. And this is where education providers are going to come into play and help. And there's all kinds of data, not data, but resources, all kinds of resources that can and will be available for appraisers who have these types of questions.
And Michelle, can I just add on to that a little bit, because you just mentioned education, just to bring to everyone's attention, if you didn't know, the AQB, the Appraisal Qualifications Board, is proposing a very formal 7-hour or 4-hour course, depending on the requirements, related to fair housing education. So I think there's a dual track going on here. You guys are saying know the laws, and the AQB will saying get the education in that. That's very important. So the ASB will not be able to answer questions such as that because, like you mentioned, it's assignment specific. And that's happens to me at my job a lot. Is I receive questions about what do I do for this assignment, and it's like I don't know because I don't know everything about your assignment, and that's not the ASB's role. So okay, so I went up on that. Okay.
Yeah, Lisa, if I could just chime in on that too. Yeah, that's a great way to look at that. You know, sometimes we get questions in and we don't know all the little nuances of everybody's questions. So sometimes it's really hard to answer something that's just that specific.
Yeah, I agree. Nick, this one is for you. This has to do with the transfers, that proposal related to other transfers. And the question is, why is it necessary to report other transfers? What impact does that have on the appraisal report process?
Sure, that's a good question, and I believe that's also addressed in advisory opinion 1. So, and going back to stump Nick a little bit here. It is a fundamental, it's reporting and analyzing sale history is fundamental to the appraisal process. It states it right there in advisory opinion 1 on line 34. Goes into a little bit more into lines 40 and 41, just talking about how the current market status and the sales history of the subject property may be useful information for the determination of highest and best use and analyses of market trends. So in the case of other transfers, I know we've heard some questions or concerns about like deeds in lieu of foreclosures or inter-party transfers and things of those sorts. The type and the extent of the analysis related to those types of other transfers may be limited. It may be very limited, being that those transfers might not have no bearing on the highest and best use or market analysis, or they may not be fundamental to the appraisal process. Those are decisions that the appraiser is going to have to make themselves.
That's really great. And just to add on to that, so what I hear Nick is saying is that the development standard is slightly different from the reporting standard. The reporting standard is just tell us what your analysis was, what you ended up with. The development standard has to do with analyzing the sales and transfers available in the normal course of business. So there's a slightly different requirement between the two.
Yeah.
Okay. Well, that's a inspection question again. How is the ASB going to provide support related to the education materials of the new ethics rule and the guidance?
I'll let Michelle take that one.
Yeah, I'm not sure I understand the question.
You know what, Michelle, that's not fair because that's really,
like question
yeah,
too.
that's more of an, yes, more of an
AQB.
AQB. So I'll just answer that. Sorry, I didn't mean to put that out there because it's the AQB. So the USPAP instructors will be trained in the ethics rule as it is now. They have the expertise in USPAPs. They will receive that training, and that guidance is a lot of what they will be learning. So that's all going to happen behind the scenes. Everybody will be trained adequately to get this understood for students taking the class. Would the use of a video equipment be considered a personal inspection, Nick?
Well, based on the current definition, it's the in-person observation of the property. So it is not going to be sufficient to claim a personal inspection. Remember, we're trying to convey to our intended users that we either did or did not personally observe the property in person. So that's a technology aided type of inspection. It's a different type of inspection being conducted. And so you wouldn't be able to certify that you personally inspected the property because that would be potentially misleading to the client. And therefore you would say, no, I did not. And then you would explain the scope of work that you did do, which could involve something additional there.
Thank you.
Lisa, I'm trying to read through the chat to try to answer as many questions.
Don't do that. That's my job.
I know, but I'm so excited to interact with everybody and just see what everyone's saying. So there was a question that came up about liability, vulnerability to the appraiser related to the fair housing laws. And I'd really like to just address that for a second. The competency rule has always included a statement that an appraiser must have recognition of and comply with laws and regulations that apply to the appraiser or to the assignment. So to answer the question about more vulnerability for stating this explicitly, I don't believe there is anymore, because you've always had, as an appraiser, to comply with these laws, recognize that they're out there and comply with them.
Great. And to follow up on that, so why is the ASB doing this now? If this has already been in USPAP, why are we proposing more language around the concept of non-discrimination and anti-discrimination? Michelle.
Well, I'm gonna jump in on that because we get that question a lot. Nick, you're welcome to jump in as well. So why now? I've been asked this so many times. Appraisers say, look, many appraisers have said to me, Michelle, we understand what USPAP says. We understand that we are prohibited from bias. But what's really important is that as the Board of Trustees chairman of the foundation says, perception is a little bit of reality there. Other people outside of our profession could not look in our standards and see what it said and understand what it said. And that is a public trust problem. The ASB must promulgate USPAP in the best interest of public trust. And when there are those that are outside of the profession that cannot open our standards up and read what the ethical requirements are. They're not appraisers. They don't know how to kind of piece it all together. That's a problem for us from a public trust perspective. So it's imperative that we make these changes so that it's very clear.
Thank you, Michelle. Nick, this one's for you. So the limited exception that you guys talked about regarding the use of protected characteristics, how does that relate? Does that include that 55 plus community situation, age 55 and over individuals?
Right. So with the 55 plus housing, you'd have to evaluate the criteria of that project, potentially using a protected characteristic such as familial status or age. And that, if that were to be invoked, you'd have to go through the exception and follow that process for your specific assignment. So if that, let's get to the, you want to jump in, Michelle? I'm trying to pull it up to the exception list.
I'm reading through the comments. I just saw one that asked, why isn't TAF educating the public? And I want to get to that one. So I'm sorry, I'm not following you there, Nick.
Okay.
We're trying to answer as many questions as we possibly can for everyone.
So the exception states, sorry, I'm getting there.
Lisa, ask the question for me again so I can hear it.
Well,
Yeah.
Basically the answer is yes. I mean, it's either it's in the law itself that the exception is allowed, or it falls under the limited exception. So it's allowed to deal with anything that the law itself allows to as an exception, or that there is no law in, but it is allowed to be considered. That's not the formal answer, because Nick was going to do his great Nick brain and give you the actual wording. So don't take my word for word.
Yeah.
This is not Stump the Nick hour, because I noticed that the two times that you said that, you were 100% correct on both of them. Can we put one more question out there? I know we're about time, but there was a question about why the foundation and other organizations are not doing more to educate the public, agents, and lenders. Lisa, I'm going to throw that to you. How about that? We'll switch up the role. Let's talk about why the foundation isn't in education. We're not an education organization.
Well, you're really answering a question that kind of applies mostly to the BOT, but just understand the whole goal of the Appraisal Foundation as a nonprofit is to educate. That's why we're here. We're not an advocate. We don't act on behalf of appraisers. We're here to provide education. So anybody that is interested in understanding the process, our requirements, we're here for you. And there's an awful lot of work going on with the BOT that would take up a whole nother hour webinar. So I'll just leave it at that for now.
Okay.
Michelle, you had another question? Oh, that was the one.
I think that was the one. Yeah.
Okay. I'm sorry. Okay. Well, I got through the majority of the questions there. You guys did a really quick, what do you call it, rapid fire as fast as you could. I appreciate that.
We were
As always,
trying,
if we didn't get to some of these questions and the ones we receive in the comment letters are the ones that inform what the ASB does. That includes the advisory opinions that you read. A lot of that content comes from the actual questions that we receive. So all these will be reused to inform any education material related to that they produce. Any comments from Michelle and Nick before we finish up for the day?
Yeah, the last thing I would like to say is truly, folks, Nick and I tried very hard to get through the presentation as quickly and seamlessly as we could so that we could get to your questions. This being the 5th exposure draft in our public meeting coming up on May 5th, we wanted to try to answer as many questions as we possibly could. So thank you for staying with us, and please send your comments in by April 29th.
Yep, thanks again, everybody. I appreciate the questions, and the board takes the time to read each one and try to understand them as best as we can so that we can address them as needed and better improve USPAP for public trust. Thank you.